All right, everybody. Hold on here. Let me get my mobile sign off here. All right. So I thought what we would do, as you know, their jury instructions are going to be something that we're going to be talking about. Uh, Hold on here. Let me turn that off in my background there. Um, so I thought, you know what? Let's. This is the perfect time to get into the jury instructions that they're going to be talking about. And now that we've seen most of the state's case, we can assess the case, and it will help you, I hope, to maybe have a little bit of a better understanding um, of what you've seen in trial. So this is the Wisconsin jury, basically the Wisconsin law. This is what the jury will be instructed on. Among other things, there'll be other instructions in there, but this will be the heart of the case of what they're going to decide. And this is the self-defense instruction that Mr. Mew is entitled to. So it states the following, and we're going to go through it here and talk about this and ask your questions as follows. I'll try to follow along in chat here. Self-defense is an issue in this case. This is what the jury is going to hear. In deciding whether the defendant's conduct, and this is I believe it'll be was criminally reckless conduct showed with utter disregard for human life. I believe that'll be the one they choose. You should also consider whether the defendant acted lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if, and this is the important part here, these three things, and then there's a fourth one because deadly force was used. In other words, it wasn't a non-lethal blow that was delivered that caused someone's death. There was force used that he would have known could have caused death. So these are the three things that the jury has to determine. The defendant believed that there was an actual or imminent unlawful interference with the defendant's person. Okay, so I want you to understand that, and we're going to go down. The nice part about this piece is this is a piece that kind of helps the attorneys interpret. So we're going to see a little case law. We're going to see a little bit of a thought process here of what that is. So many people are thinking, did it have to be deadly force? Not necessarily. It was an unlawful interference. So what the defense is showing here, and this is what I've been arguing the entire time, is you see in the video where Mr. Mew walks away. He is then impeded by the other group who's being called over by the group of high schoolers. They then impede his movement. They even testified we were creating a wall. The problem is this wasn't a campground. This wasn't an area that any one of those parties had domain to. This was a public river that they each had a lawful right to be walking down. They stop him when he's trying to get across to his parties, to the party that he's going back to. He did retreat, and then he's coming around, and then those people come in, and he starts trying to explain, I'm looking for a missing phone, which he had a legal right to do. I dropped my snorkel. They're essentially saying I'm a, predator of some sort. He's trying to explain all this while these boys are yelling at him. So, now the reason why the state needs that punch to happen is because that takes away that any argument that those individuals were unlawfully interfering with him. And by him punching the girl, now he's unlawfully interfering with them, and anything they do is in self-defense, and anything he does is as an aggressor. Now, the second factor is the defendant believed that the amount of force the defendant used or threatened to use was necessary to prevent or terminate the interference. So the question is, what else could he have done in that instance? Could he have done something else? Could he have used some other form of force when he has a whole group of high school boys coming on him, pounding on him, punching him, pushing him down? When he pulls the knife out, was it an amount of force that was necessary to get him out of that situation? 3, were the defendant's beliefs reasonable? In other words, would a reasonable person believe under those circumstances that he was under threat, that there was a threat, that it was reasonable to do what he did? And in this instance, I think that's part of why the defense had the witnesses that we just saw on, because they were trying to get perspective from them to say, what was your thoughts on what you saw? Did you think, and that gentleman even said, I had my knife. I was getting, like, I was concerned. So, and again, that's what we've all been talking about in chat. And a lot of us have been chatting about saying, hey, for us, when you see the tape and you see what was transpiring, was it reasonable? He's under attack. He's getting knocked down. He's getting punched. He doesn't understand why people are accusing him of trying to look at little girls. He's trying to find a phone. He drops his snorkel. He thinks they found the phone. So was it reasonable for him to pull out his knife at that moment when he's getting beat up by a bunch of young people who are converging on him and accusing him of being a pedophile? I think it is reasonable. Now, the fourth factor that has to be considered by the jury, if there's evidence that the force used was intended or likely to cause death or great bodily harm, is this: the defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself or herself. Now, this is going to be what the state is going to die on here and say, they were punching, he pulls a knife out, that isn't reasonable that he should have done that. However, the fact that he was getting punched, repeatedly punched, pushed down, and on rocks in the middle of a waterway, and I absolutely could have reasonably believed, hey, my head hits one of these rocks, I fall, I lose consciousness, I'm drowning to death or getting a serious head injury. Great bodily harm. So it's not, the standard is not necessarily death. It would be great bodily harm. Could he have received great bodily harm by a whole pack of high schoolers beating the hell out of him thinking he's a pedophile? Absolutely. So I believe here, and again, the state has to overcome these four things, okay? They have to overcome, the river can be a factor, Jeff, absolutely. But these four things, the state has the burden to prove beyond a reasonable doubt that these were not, that he did not believe these things. So if there's any doubt, this is why the state says, if there's any or the defense said, if there's any reasonable hypothesis that leads to the innocence of Mr. Mew, it's not guilty. The burden of proof is on the state. Now, and some are going to say, here, well, wait a minute, it's a self-defense. Well, they're going to get into it. That bar is extremely low in Wisconsin. Wisconsin is a very friendly self-defense state. So here is going to be what the jury will be instructed on as far as determining whether the beliefs were reasonable. A belief may be reasonable, even though mistaken. So, in determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. So it doesn't matter what he finds out later. It matters only what he saw in that moment, and that an individual, a 52-year-old man who's looking for a phone and a snorkel, starts getting heckled by these kids, is accused of being a pedophile, is advanced upon, attempts to go explain this to another party who's coming over. He's told it doesn't matter anymore. Your phone doesn't matter. And at this point, they start putting hands on him, and an altercation occurs to which he now begins being punched. Now, the issue is if they believe that these kids were okay with what they were doing, and this is why the state is going to great lengths, because in the event that the kids will be looked at as hecklers, and that they were lying about the pedophile stuff, and that they were simply trying to get a rise out of him and create a scenario where they were going to have a physical altercation they could capture on video, then Mr. Mew is not guilty. That is a reason, because at that point, there was no belief on the part of those kids that they were correct in trying to restrict his travel, in trying to, when Madison puts her hands on him and pushes him back, or whatever she did that precedes the slap, punch, push, whatever it is. The defense says it's a push. Other people have said it's a slap. Other people have said it's a punch. Remember, it's got to be proven beyond a reasonable doubt that it was a punch. So if there's any doubt whatsoever as to what it was, that sways to Mr. Mew. So that is very, very, very important that you understand that. And it's also very important that the jury understands this. This is going to be one of those cases where the jury, absolutely, I agree with you. The river is a huge factor. And again, as you can see here, that falls under the circumstances that existed at the time. He's in a river. He's getting attacked by high schoolers. There's rocks all around him. He's getting pushed down. This group believes he's a pedophile that's trying to do something with young girls that they allegedly have on tape. This crowd is becoming angry and crazy and coming at him. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. So this is important. This is what the defense is going to really make a huge argument about here is, listen, you are not to view it from the point you're at now. In other words, finding out what the injuries were, finding out what was really going on, finding out, looking at it and judging it and saying, well, I would have done this or you could have done that. It's got to be viewed from the standpoint of the defendant in that moment, at that moment that he decides to act. And was it reasonable? Was it a reasonable act that he could have thought to himself, I'm under attack and I'm going to potentially have my life threatened, or I'm going to be facing great bodily harm? Remember, it's not life-threatening in Wisconsin. It's life-threatening or great bodily harm. And if they're impeding him or interfering with him in any way in an unlawful manner, and in this case, they were heckling him. In this case, they were going after him. In this case, they were trying to incite people on the lake to hurt him. That is a criminal act by those people, impeding him and impeding his ability to enjoy his time on that river and try to find that phone. They had no right to ask him not to. So for everybody that says, hey, he should have just walked away, that's what the state tries to say. He couldn't walk away. They impeded his ability to do so. He wasn't running around attacking people. He didn't start stabbing people on the lake. He's trying to explain himself, and he's trying to figure out what the hell these kids are doing. All right, so here we go. Let's continue reading. If retreat is an issue, add an appropriate instruction here. See Criminal 810. If there's evidence that the defendant provoked the attack, add appropriate. So there are some other instructions that will get added, and I don't have those. And then they're going to continue with the definition elements of the crime of first degree unaliving. Add the following definition of recklessness or negligence. I don't think they're going to be adding that. So the final line, this final paragraph will be read. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created an unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. I want to repeat that. The burden is not on the defense. It is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. For first-degree recklessness offenses, also add the following to the definition of utter disregard for human life. So this will come in because it's a first-degree offense. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct showed an utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. So now these are some comments. This is some footnotes here to kind of help guide the understanding of Wisconsin law. So one thing, I'm not going to go through all of it, but I wanted to read this part here. Wisconsin law establishes a low bar that the defendant must overcome to be entitled to a jury instruction on the privilege of self-defense. So all the defense has to do in Wisconsin is they just have to establish that they are entitled to the jury instruction. That is it. There is no burden beyond that. Now, understand this, and this will help you to understand some of the cross-examination, some of the things you've seen. A defendant needs only to produce some evidence in support of the privilege of self-defense. Evidence satisfies the some evidence quantum of evidence, even if it is weak, insufficient, inconsistent, or of doubtful credibility or slight. Though the burden of producing some evidence of a defense is commonly referred to as the defendant's burden, that is not literally correct. The source of the evidence may be facts presented by the prosecution, facts elicited from prosecution witnesses by defense cross-examination, or evidence affirmatively presented by the defense. When applying the sum standard, a court is not to weigh the testimony, as this would invade that province of the jury. Instead, the court should focus on whether there is some evidence supporting the defendant's self-defense theory. Failure to instruct on an issue which is raised by the evidence is error. So, again, the burden in this case is not to prove self-defense. It is simply to show, to make sure that some evidence exists that self-defense could have been possible, which then triggers this instruction, which will then allow the attorneys to argue in closing arguments for self-defense. And then you've seen now what the standard is that the state has to overcome once that instruction comes into play. In State v. Johnson, the Wisconsin Supreme Court concluded that the trial court erred by declining to instruct on self-defense. The court held that although Johnson unlawfully entered KM's home in the middle of the night, there was some evidence that he had an objectively reasonable belief that he was preventing an unlawful interference with his person. Although the physical attack in Johnson occurred entirely inside KM's home, the opinion did not interpret, apply, or limit the Castle Doctrine in any way because the court was tasked with examining Johnson's, not KM's, actions. Therefore, this decision did not alter the some evidence standard used to determine whether a jury should be instructed. Further, for example, we'll read this portion here too. The committee concluded that the description of the privilege should be integrated with the definition of recklessness or negligence. This is because both concepts require that conduct created unreasonable risk of death or great bodily harm. A risk is not unreasonable if the conduct undertaken is a reasonable exercise of the privilege of self-defense, because criminal recklessness or criminal negligence and lawful actions in self-defense cannot coexist. It is best to advise the jury to consider the law relating to self-defense when considering those elements. For example, the issue of self-defense might arise where the defendant is charged with recklessly causing great bodily harm in violation of, I'm not going to go through read that, which provides that the second element of that offense is that the defendant recklessly caused harm. Wisconsin 801 should be added to the definition of recklessly if the evidence provides the basis for the privilege of self-defense. This approach treats the privilege differently in recklessness cases than in cases involving the intentional causing of harm. In the latter, intent to cause harm in self-defense can exist at the same time. Thus, the absence of the privilege is identified as a fact that the state must prove, in addition to statutorily defined elements of the intentional crime. So the reason why I'm reading that to you is because what it's saying is this is not a case of recklessness. This is a case of intent to cause harm. So did he intend to cause harm to those individuals? Yes, he did, but it was in self-defense. And the state must prove not just that he intended to cause harm, but they've got to prove that it wasn't in self-defense. And they've got to prove that beyond a reasonable doubt under the four standards that we read above. For purposes of self-defense, unlawful means either tortious or expressly prohibited by criminal law or both. Further instructions on what constitutes unlawful interference in the context of the facts of a particular case may be desirable. So let's pay attention to this here, because again, this is going to kind of uncover for you to what the state has been, attempting to prove here. The word unlawful appears in sub 2 of 939.48, which provides a person who engages in unlawful conduct of a type that likely to provoke others loses the right to claim the privilege of self-defense. The court held that engaging in what would be considered disorderly conduct could constitute unlawful conduct for the purposes of 939.48. The unlawful component of unlawful interference is just one part of the predicate for invoking the privilege of self-defense. As stated in the instruction, the defendant must have believed that there was an in actual or imminent unlawful interference with the defendant's person and must have believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference. So I want you to understand what they're saying there. What were these kids doing? They were attempting to incite individuals to violently harm him, believing he was a pedophile. As state law, that Wisconsin state law in the Supreme Court has held that engaging in what would be considered disorderly conduct could constitute unlawful conduct. That would be disorderly conduct, inciting people, yelling at people, calling someone a pedophile. A person who engages in unlawful conduct of a type likely to provoke others. Those kids were engaging in conduct that would provoke others. They lose the right to say what they did was self-defense. They lose the right to say that so this is important because when that woman, whether it's a girl or a guy, puts her hands on him and he's being heckled and they're coming at him and they're trying to incite him and she puts her hands on him, she lost the right to claim self-defense. As a result, that's an aggressive act that's interfering with his person. As a result, he gets the self-defense privilege, not her. And it's why they're trying to say, well, it was a punch that there was no reason for, that he didn't do anything, and that she didn't do anything preceding the punch. But if you follow the circumstances of this case, she comes at him. She's angry. She's yelling at him. And she appears, in my opinion, to hit him with the phone. He gets choked. And he does something, slaps, punches, pushes, whatever. We know it's probably not a punch because she doesn't look like she got punched. But he does something in reaction to that. Whatever he did in reaction to that, she lost the privilege of claiming self-defense because her conduct was such that it was provoking, it would provoke others. It was also disorderly. And it was being based off a basis of other people that were claiming he was a pedophile, which was wrong. And there was a group that was inciting everyone on the riverbed to come at him. So and let's consider reading the rest of this here. The unlawful component of unlawful interference is just one of the predicates for invoking the privilege of self-defense. As stated in the instruction, the defendant must have believed that there was an actual or imminent unlawful interference with the defendant's person and must have believed the amount of force he used or threatened to use was necessary to prevent or terminate the interference. So did he believe he was being interfered with? He gets punched. He gets knocked down. He's got a group of people and he's got a little pocket knife on him. What's he going to do? Does he think he's going to kill somebody? It doesn't really matter. He used it in a way that was just meant to get people off of him. It's unfortunate a young man died. But when you look at the definition of Wisconsin, as explained here by the law, you come to the absolute conclusion that what he did was lawful. Number 3, this treatment of reasonably believes is intended to be consistent with the definition provided in 939.22, which I don't have in front of me. 4, the phrase in the defendant's position under the circumstances that existed at the time of the offense is intended to allow consideration of a broad range of circumstances that relate to the defendant's situation. Now, and it gets into, for example, with children, the standard relates to a reasonable person of like age, intelligence, and experience. So the way we would interpret this here is also with children and with older people. So he's an older guy who's had a heart surgery, who's not physically fit, and they're allowed to consider that. They're allowed to consider the circumstances. The river, which Laura and Jeff, you were just saying the river. They're allowed to consider that. It just says it under the Mockley versus Junovich. They're allowed to consider that. That is a consideration a jury will absolutely be able to take into account under the idea of taking the circumstances that existed at the time of the alleged offense into account. Another situation where the personal circumstances becomes important in defining self-defense standard is in a case involved. Well, we're not even going to get into that because that's not what we have here. But so Number 5, the committee concluded that consideration of the privilege of self-defense is relevant to both the unreasonable risk and utter disregard components of first-degree recklessness offenses. Conduct does not create an unreasonable risk of harm to another if the conduct is undertaken as reasonable action in self-defense. Recklessness and reasonable exercise of the privilege cannot coexist. Thus, the committee concluded that it's best to advise the jury to consider the privilege of self-defense when considering the unreasonable risk component of recklessness. So for those of you saying, well, could it be a lesser offense? Could they jump into that? No. I mean, they could, but no. There's no theory that gets there if self-defense is what it is. It's either the top offense of first degree intentional homicide, or it's not guilty. There's really no two ways around this because there's nothing reckless. You're not going to say, well, the only way you get to him using the knife is say, well, it's not like he accidentally pulled the knife out. He is admitting, and the defense is conceding, that he intentionally was stabbing people that day. Not with necessarily the intent to kill, but it was the intent to defend himself and get these kids off of him because he thought his life was in danger or that he could face grievous bodily harm and great bodily harm. Number 6, let's look at it says the last 2 sentences of this paragraph were added in response to the decision in State v. Austin. The court held that the jury instructions given in that case. Okay, so this is just saying really nothing that we need to worry about right now in this case necessarily. The committee concluded that the consideration of the privilege of self-defense is relevant to both the unreasonable risk and utter disregard components of the first-degree reckless offenses. Conduct does not show utter disregard for human life if it is undertaken in a reasonable exercise of the privilege of self-defense. Thus, the committee concluded that it is best to advise the jury to consider the self-defense when considering utter disregard element. So, again, self-defense is the self-defense. It's either self-defense or nothing. That is one thing that they're holding here, is that you cannot see self-defense inside of a recklessness. In other words, he was being reckless with a knife and killed this young kid. They cannot coexist. The jury either finds it's self-defense or finds it's criminal and it was intentional. The last 2 sentences of this paragraph were added in 2014 in response to the decision of State v. Austin. Austin was concerned with unreasonable risk element of the offense, but the same concern should also apply to utter disregard element of first-degree recklessness offenses. The first of the added sentence is intended to make it clear that the prosecution must prove the absence of self-defense once raised to meet its burden to prove utter disregard for human life. I want to repeat this. The first of the added sentence is intended to make it clear that the prosecution must prove the absence of self-defense once raised to meet its burden. So they have to prove beyond a reasonable doubt that self-defense was absent. There can be no doubt to that. There can be not a reasonable doubt that exists in those 12 jurors' minds in order for them to convict here. The second added sentence is intended to emphasize that even if the state succeeds in proving the absence of self-defense, the jury still must be satisfied by all the evidence that the circumstances of the defendant's conduct showed utter disregard for human life. So, again, but I think, the way the state's theory is going in this case, I think that if you remove self-defense, there's an utter disregard for human life. I think everyone would agree. If you're just wantonly stabbing people on the side of a riverbed for no reason, which is what the state would have you believe in this case. So, look, bottom line here, when you read this, and you conclude and you read the instructions here that the jury is going to be given, I don't think you can get it. I don't think anybody's going to disagree that the state has a tough road. And I believe right now we can conclusively say, if I'm sitting on that jury, I'm finding him not guilty. And again, we've not heard all of the state's case. We still got some witnesses tomorrow. It looks like they're going to rest tomorrow, and we're going to hear the rest of the defense. I got a feeling we're going to hear from Mr. Mew because it's important, as you can see. If you want to, if you wonder why I say that, I want you to the one factor you have to understand here in this in the instructions you hear here is it's the part that says the defendant believed that there was an actual or imminent unlawful interference. You can't really get there with that without hearing from the defendant himself. And since the defendant didn't give a statement in this case to the police, then he has to testify. And how he comes across in that testimony, I think, is going to be key in this case, whether or not he walks away from this or not. If he gets up on the stand and he comes across the way some of the individuals that come in my chat who are not in the Mew camp, who believe Mew is guilty, and says, hey, he comes across as has that demonic look, that removed look, doesn't show adequate emotion, then I think the state is going to absolutely have a much easier case here to be made and much easier time proving their case. But this is what they're going to be talking about. These jury instructions are key when this judge charges the jury, which hopefully, again, I'm not sure if Wisconsin charges the jury before or after closing arguments. My dad used to say, West Virginia always charged the jury before. So it was very important that you got the instructions correct, because then when you argue to the jury, you take these instructions and you argue these instructions straight to the jury. In states where you don't get that, then you're going to just have to argue what is coming in. But, you got to be careful, and you have to get I believe you have to get permission, they should already have an idea of what's coming in, but you got to make sure you're not going to go outside the bounds of what's going to come in. But the idea here is that the state has to prove beyond a reasonable doubt. And I just do not see how you're going to get 12 people in that jury room viewing that video who are going to look and say, yes, beyond a reasonable doubt, he wasn't acting in self-defense. No way. I just don't believe it. I just don't believe it. So with that said, guys, we're going to conclude. Day 6 is concluded. It looks like day 7 will be the defense. And put in the comments what you think, how you think it'll be this evening. I'm going to do. I guess this evening I'm going to put the recast up eventually. But I also am going to do, I think, an episode of Justice Watch Live tonight as well. I want to talk about the Diddy, some updates with the Diddy case, and then we'll talk a little bit about this case. I've also got to get out and do episode 2 of the Gagged series for the Tyrone Tucker case. I don't know if you guys have caught the first episode. Catch the first episode. Second episode is coming. We're going to be reviewing the contested hearing regarding the first gag order that was put in this case. And understanding that gag order, if you're interested in that case, and all of you should be, if you're interested in this case, the Tyrone Tucker case will have you absolutely sleeping none at night until this case concludes, because Tyrone Tucker is an innocent man, just like I believe Mew is, but he's currently, going to be facing trial potentially later this month, or not later this month, later this year. Potentially in May, and the state of Florida is doing some very egregious things. You think what's going on in this case is bad? You ain't seen nothing yet till you see what's been going on in that case. But check it out. Episode 2 will be coming soon. I've just got to get it concluded because I've got to read a 53-page transcript, and trying to do that, cover trials and all that stuff has become, and various other things in family life has become a bigger thing. But anyways, check it out when it comes out. Get caught up on episode 1 in the meantime, and then, like I said, I will be putting up the recast. Check it out. The algorithm hasn't been pushing it like it did at the beginning, so I don't know. So I need you guys to come in and like the stream, and try to get as many people in, because again, cases like these, we want to have people looking at this stuff. We want people to pay attention to a case like this, because if he does get convicted, we want as many people looking at it and questioning, hey, should he have been convicted in this case? Is this the right verdict? Should the state be able to get away with literally suborning perjury in front of our eyes? I mean, the young man that testified at the opening of today's case was pathetic. I mean, he was lying openly. He had a police statement that he basically just said, nah, I don't care what it says. I'm telling you what it is today. And what I'm telling you today is the popular story. He actually said his memory is better today. Excuse me, sir. You were drunk high, probably had a 0.2210 blood alcohol level, and you're telling me your memory, what you're telling me your memory today after you've watched videos, talked to your friends, and probably viewed the trial. You're telling me your memory is better today? No, I don't think so. I think you're lying, and I think that shows it. And I think the jurors tend to be very smart people and very serious people. And I think the jurors are going to see through this entire case with the state. It's such a bad case. It's such a stinky case. And when you look on Law and Crime, I was looking at Law and Crime today. 45% say guilty, 45% say not guilty, and 10% said hung. So we're at 55% either hung or not guilty. And commonly, when you start to see numbers like that showing up on Law and Crime polls, that speaks well for the defense, because that's telling you there's reasonable doubt all over the case. And we're not even through the state's case. So yes, well, thank you, Sandy. Yep, absolutely. We're on the same case again. I appreciate it. Yep, absolutely. I appreciate all of you, Laura, Sandy, Jeff. Let's see here. We had you guys have all been in here all day. I appreciate it. Appreciate a big thanks goes out to our member right now, our sole member, Laura Connor. She's our inaugural member and only member right now. So hopefully we can give her a little company. Consider that at some point, and become an official Justice Watcher with all the perks and the emojis, and you get members only videos released early. When we get a few more people in, we'll do members only chats, and we'll do some members only live streams where we'll come in and do a more invasive or more intensive breakdown of cases and get into some things and answer questions. So, I look forward to being able to do that as we build the community and build the membership base. So anyways, but a great day today, guys. I really appreciate it. I appreciate everybody that came and hung out. Be on the lookout. I'll normally give a 15 to 30 minute head start when I'm going to go live. At a very minimum, or at least do the recap today where we're restreaming what we watched and sharing our live with everybody. So it was great. Yep. Caught up on 1.75. Yep. But I appreciate you all. So with that said, guys, we will be back tomorrow. Get started again. I will attempt to not have the same technical difficulties that we had at the beginning of the last stream, which I had to kick the whole stream out. Hopefully everything will go smoother. And we'll go from there. So with that said, guys, I appreciate you all. Let justice prevail, and I will be talking to you guys soon.